Yeah.
Okay, you should be live.
All right. Good morning. This is Tuesday, February 2nd, Groundhog Day. Down here in southern Vermont, we had a tough ride to work. I had to go out and shovel about 8 inches of snow before I could get to the newspaper. That's the full extent of my walk this morning.
Good thing Campion wasn't on the front page.
I know, poor thing. He's in Montpelier, probably sitting in my seat. I sent him a text asking him not to mess it up. So I always keep mine clean, and his is always messy. Today we're dealing with S18. It's an act relating to limiting earned good time sentence reduction for offenders convicted of certain crimes. I did receive a letter from an offender named Sean Breyer, that I will just mention that he did send me this letter, vehemently opposed. He's an offender who would be impacted by this change. He feels that he feels there's a over sentencing as a result of plea deals where prosecutors overcharge, and that's created a increase of long-term inmates in our prison population, requiring contracts with private prison companies for supplemental housing. And says he understands the Attorney General's perspective and the feelings of those who've been victimized. But I disagree that a victim's long-term term and expectations from a flawed plea deal negotiation process should exclude these offenders from demonstrating their rehabilitation while incarcerated and earning some credit for it. Basically, the letter from Eric, where are we? Maybe we should hear from Matt first. He sent an email to us suggesting that there'd definitely be litigation where we'd pass S18. So I don't know if you want to share that with us, Matt.
Oh, sure. I mean, this is something that I brought up relatively early on. And this was honestly the basis when there was a change in good time, 10 plus years ago, maybe more than that, during the Douglas administration, where all good time was eliminated. The individuals who were under the various forms of good time at the time had a vested right in receiving the good time that they, under the systems that they had. And the only way that you could start a new system, basically that had no good time attached to it, was to either allow the existing systems to continue going forward and allow them to earn it, which would have been very unwieldy, or to do what you did do, which was to grant everybody who had a right to good time under the then existing statutes, the good time that they would have received had they earned it. And that's what you did, is that you so-called trued up the good time system by awarding everybody under whatever system was available. There was a time when there was good time off the min and the max. There was a time when there was good time only off of the max. And then there was the elimination of good time. And I believe actually there was a third iteration where the numbers were actually different. Now at the time it was 10 days per month, and I'm doing this in gross terms so that so that we don't have to get too much into the prison math. But
Yeah.
30 days served got you 10 days. So it's basically a 1/3 reduction in your sentence. And depending on what system you are on, it's off the min and the max, or off your max, except for the people who were had life in prison cases, like as your maximum. The others were getting it off the minimum. In any event, you trued everything up. Now, as of last year, when you passed the bill to grant good time under our Constitution, which is and has been interpreted many times regarding the application of laws to criminal defendants and ex post facto application. There's a statute that sets it forth and says that you pass a statute that grants rights to particular individuals. If you then subsequently change that statute to take away that right into the future, you can't take away a vested right that you've already granted to the people who are in the facility or in the jail. If you're, as far as for example, in this case, it's good time. So when you passed the statute last year, you granted everybody who was under sentence the right to good time. Right? Now, it doesn't matter if you wait 10 years or if you wait 10 days. All of those people during that snapshot period of time, until there's a change, have a vested right in that good time. And so going forward, you can change the law and say, well, we're not going to allow good time for people who are sex offenders and murderers, just to use gross terms rather than the specific crimes. But all of the people who are already under sentence for those things right now have a vested right in that that you can't take away because you made that change last year, and under the Constitution and your statute and the statutes, it's 1-214, Eric, Title 1-214, Section 214. I had written this all out, and I was working on some budget stuff, so I don't have that right in front of me. So I'm just basically discussing this with you without those notes. In any event, whatever you do now is going to only be applicable to the people who go under sentence going forward. It's not going to apply, well, frankly, to any of the victims folks who you have coming in and testifying that they don't want this to occur. It's going to apply to future victims. There's actually so little dispute about this that the last time you went around doing this, the legislature just granted everybody all of their good time going forward without ever having them earn it. Now, in this particular case, I don't think that that's really what you should do if you want to change the law. What you should do is identify the relative small handful of people, of whoever, if you limit it to aggravated sexual assault and first-degree murder and aggravated murder, then you are, you have a very small universe of people who this is going to apply to, and then going forward, it will. You can do what you want to do without impacting the rights of the people you granted this right to when you passed the statute last year.
Senator Baruth has a question, but and then I have a follow-up. Go ahead, Senator Baruth.
Okay, Matt, I just want to make sure I'm understanding you. So we've been talking about the bill as if it were to pass, there would be a group of people who received good time under the bill we passed 2 years ago or last year, whenever it was.
A couple months ago, yeah.
A couple of months ago. And then their good time would stop on the passage of this bill.
No,
Okay, so that's my question is, we've been proceeding as though that were a possible path. You're saying that that's just on its face impossible or illegal.
correct.
Okay. Just wanted to make
But-
sure
But may I ask, so my understanding of what we're doing here was to limit it, and we can argue about who it should be applied to. I think that's still to be determined in committee discussion too. And I'm not sure that the list of crimes we have is the right list. But let's just say, for sake of argument, it's the small group you just described: aggravated sexual assault, murder. So they were sentenced with no good time, right?
Right,
So
correct.
that's the but so
There-
what you're arguing is that once we've granted this, we've automatically given it to them, and we can't take it. We can't change that. Is that
Correct.
your argument? I mean, the other group, the group you're talking about, the group you're comparing, had already been sentenced with the understanding they were going to get the good time. This group's been sentenced with the understanding they weren't going to get good time. So
Right,
I
but
see it
what
as
you-
somewhat different. What am I missing?
Well, what you've done is you've granted them a right. You've improved their situation. And once that applied to them, you can't take it away. That's the point. And that's what if you take a look at 1-2-14 and the constitutional cases that support that, that's what the basis of that is. So, I know what you're saying as far as the equity of it. Is it fair for someone who didn't have an expectation 20 years ago to have it given to them and then taken away? Well, what the law says is if you vest a right in somebody in a criminal case relative to their sentence and punishment, you can't subsequently take that away ex post facto, even if you do it during the interim period. It wouldn't matter if it was, if, like I said, if what you had just done, you waited 5 years and then changed it, it doesn't matter. It's the same issue because they'd be operating under that 5-year period of time.
We're not
It's
taking
just that
away
the thing that makes everybody anxious about this is that it just happened a couple months ago.
But we're not taking away whatever they might gain between now and the actual passage of the law. Doesn't matter.
Doesn't matter.
I wonder if we could hear Senator Nitka.
Eric had a comment, but then I wanted to ask something too. Are you saying, Matt, that based on the law that went into effect on January 1, everybody in prison, including, murderers, all those people, are right now falling into that category where they would have a vested interest?
Unless they have
Yes.
life without parole.
Correct.
Unless they have life without parole.
Right.
Eric, did you have a comment? I was going
No,
to
I-
call on David Scher.
No, I was just pointing out that the statute was on your webpage, so that Matt was referring to the fact that he didn't have the language in front of him. But in case you want to look at the language while you talk about this, it's Peggy posted it.
Good for Peggy. Thank you, Peggy. Now I got to get to the webpage. Yep, Tuesday, February 2nd.
Don't thank me. Eric sent it to me.
214, general provisions. Okay, David Scher, any comments? I'm sure the Attorney General knew about this.
Yes, Senator, it is something that we had thought about in drafting the law. And We understand, of course, that the inmates who are incarcerated now, to whom this change may apply, may file suit, and that may even be the obligation of the Defender General's office to pursue that. But we do not believe that the law, that there's this sort of once granted, once given, always held right. We read the law differently than that, and we think that any lawsuit that's filed is not likely to succeed. Let me explain that a little bit more. There's two related but not identical concepts that the Defender General is discussing here. One is the prohibition on ex post facto laws, which is a constitutional prohibition in the US Constitution, and certainly one that applies to Vermont. And the second is the statutory provision in 1 VSA 214. Again, they have a similar operation, but one's statutory, one's constitutional. With respect to the constitutional limitation, it's important to understand what exactly it is, and then we can explain why this proposal is not applicable, or I should say why ex post facto concept is not applicable to this proposal. I'll read to you a one sentence definition, one of many in Vermont case law describing ex post facto laws. So this one is in re Blow from 2013, I believe. It says, a prohibited ex post facto law is one that is or is applied in a way that is both retrospective and more onerous than the law in effect on the date of the offense. That last clause is essential. It is the key to the discussion we're having today, which is that what matters is what the law was on the date of the offense. What we're doing here in this law is we are not changing anything that was in effect on the date of the offenses that this law would apply to. By definition, these would all apply, by definition, both of last year's law and this one. These are all offenses that occurred and were sentenced before the change in the law. So bringing what this law proposes to do essentially is put offenders back in the same position that they were at the time of the offense. They are not, this law is not making any punishment more onerous. It is returning to the state of the law at the time of the offense. In fact, it could give some people a slightly better outcome, because we are allowing the that which they are accumulating right now, potentially accumulating right now, that good time that they're potentially accumulating right now, they could hold that. So they might even be in a slightly better position than they were at the time of the offense. But that's the key concept here, is we are not going back and changing and making more severe a punishment from that was in place at the time of the offense. And that's what ex post facto laws are applicable to. And that's the key difference also with the earlier earned good time change. There, the issue, one of the main problems, and that was a very complicated change. There was a bunch of problems there, but one of the problems with respect to ex post facto was that you were potentially changing somebody's punishment and making it more severe than it had been on the date of the offense. And that would not have been allowable or constitutional, because it's not an open and shut case, but there's clearly inmates would have had a strong argument that they were potentially being exposed to more severe punishment. I think that argument was a likely winner, and the legislature couldn't do that. But again, that's not the case here. You are returning people to the same position they were in at the time of the offense. With respect to Section 214, Section 214 of Title I, it's a similar issue. The provision that's applicable to criminal offenses in that is, I'll say frankly, not written in a way that we would probably write a statute today. It's a little bit confusing to follow, but I'll read it quickly and then explain. And there's a case that explains it a little bit more too. It states, the relevant provision states that, and when I read this, listen again to the last clause of what I'm saying, because that's the key here, but I'll read the whole sentence. If the penalty or punishment for any offense is reduced by the amendment of an act or statutory provision, the same shall be imposed in accordance with the act or provision as amended, unless imposed prior to the date of the amendment. And that is a key distinction here with respect to 214. And there's a case, I believe it's State v. Barron from 2011, that explains that final sentence a little bit further and says, State v. Barron reads, the sentence at issue here in State v. Barron was imposed prior to the date of amendment. And State v. Barron basically says, that is the key clause here, the key relevant clause, and that would be the same in these cases too. These are all sentences that were imposed prior to either of the statutes we're talking about here. So 214 wouldn't apply because, again, the sentences were imposed prior to the date of amendment. So it's our read that this is squarely lawful. It is not placing anybody and forcing them into greater punishment than they faced at the time of the commission of the crime or at the time that they were sentenced, to the degree that that is the more relevant inquiry under 214. And I think the case law states that plainly.
I was somewhat tempted to ask Judge Gerson if he wants to weigh in, but my guess is he'd prefer not to give us his ruling at this point.
It sounds like it might come our way, Senator, depending on what you do with this bill. So I will not offer an opinion at this time, but thank you.
Well, thank you. Matt?
Could I?
Yeah, please.
I appreciate what Dave Scher is talking about, but he misses the key point of what 214 is talking about. If you read sub A under 214, the amendment or repeal of an act or provision under the Vermont statute shall not revive an act or statutory provision which has been appealed. And then under B, the amendment or repeal of an act or statutory provision except as provided in C below shall not. And then you look at 2, okay, because this is not a new sentence, but affect any right, privilege, or obligation or liability acquired, accrued, or incurred prior to the effective date of the amendment or appeal. And so what's going on here is you guys last year granted a right or privilege, and that right or privilege vested in the defendants, in the people who are under sentence. And as a result, if you subsequently change that, you can't take it away for those people who are subject to that right being vested in them. And so it doesn't have to do with a change in their penalty or punishment so much under C, but as to a right or privilege that has been granted to them by your statutory change last year. So I do agree with Judge Grierson completely that he or his minions will have the ability to take a look at this, and we will see what happens. But just to let you know,
If we pass the bill.
We have this one teed up.
I appreciate that, Matt. Senator Baruth.
Matt, I'm just wondering if you can respond specifically to David's unless clause, that last clause that in both cases he had us focus on. What's your specific answer to that piece?
That has to do with the penalty or punishment for the offense, not to the right. Granted in good time.
No.
So you aren't changing a sentence. You can't change somebody's minimum or maximum sentence. But what you've done is granted good time, which is not a minimum or maximum sentence. It's a right that is outside of the sentence itself.
Thanks.
Because there's no guarantee of it.
Well, we could not withstand 2014, right? 214.
I don't think you can do that.
What? You can't? We can withstand the law, not withstand anything. We wrote the
Yeah,
law. I guess we could repeal it if we wanted to.
I think it's constitutionally based. What I think 214 did is take a collection of ex post facto case law and explain it in the statute, which is what sometimes you do to clarify or organize case laws as they come down over a period of time.
Understood, but I don't know why we couldn't notwithstand it, and notwithstand a lot of things.
Well,
David, did you want to comment on notwithstanding?
Yes, Senator, a couple comments, and I certainly understand that that the Defender General's office has this teed up, and courts will be weighing in on this. So our discussions here today will be repeated later. But I do think, first, to answer your question initially, yes, I think you could do a notwithstanding. This is a statute. It's up to the legislature to treat it how it will. And to the extent that it is constitutionally based, and I agree with Defender General Valerio that aspects of it are certainly constitutionally based. We already discussed why it's our reading that the ex post facto provisions don't apply to this. A couple things I'll just say briefly, and again, I understand we're wading into the waters of statutory interpretation deeply that will be waded into again in more detail in court. But I would just note a couple things. One, that the subdivision B that the Defender General pointed to notes that subsection applies except as provided in subsection C, which was the subsection I was reading from. And it's our read that subsection C is what would be applicable to a criminal offense. We read the statute to apply that way, and we believe the case law has applied it that way. That being said, assuming for the sake of argument that subsection B might apply, which again is not a read that we have of the statute, we would say that when the statute says affect any right, privilege, obligation, or liability acquired, accrued, or incurred prior to the effective date of the amendment, what that's saying is that you can't take away something that has been gained, but it's not making any statement about what could happen in the future. In other words, I do think that provision of the statute would mean that you could not take away from an inmate good time that they have earned already by operation of law, which this proposal does not attempt to do. But that would make that unlawful and would supersede any attempt to do so. But we don't believe it speaks to future rights. It speaks to rights already accrued. So again, I recognize that this is a matter of statutory interpretation that will be discussed again later, but I just wanted to give the committee our reasons for why we don't believe it applies in this case. And we do think a notwithstanding is appropriate in this case if the committee chooses to go in that direction.
Yeah, I just would like to understand, I'm reading over the 2602 lewd and lascivious conduct of the child, which is on our web page. If we were to say that a person convicted of little b2, little b, what am I at? 2602A, little a2. The section should not apply if the person is less than 19 years old and the child is at least 15 years old and the conduct is consensual. This is the old age gap Romeo and Juliet thing. And I find that actually problematic. If the child were 15 and the guy was 20, or actually 19 years and 1 day, and the girl was 15, let's say, that would put him into this category, correct? That's one of the areas where I'd like to explore as we look at the crimes. But if we were to change that law, how would it affect people currently sentenced? If we just said, okay, make it 14 rather than 15, how would that affect people currently sentenced for that crime?
Senator, is that a question for me?
Either one of you, actually.
Okay.
I'm trying to understand this 214, Title 1, 214, and the other law. I mean, the constitutional factor.
It wouldn't affect anybody who's currently sentenced, although I think that a person would have a legitimate argument to attempt to get their conviction sealed or expunged based on the fact that it was something was made effectively legal that used to be illegal.
If you remember back, that's the way the Senate passed the bill back in 2010, I believe.
Right.
It was 14, and the House insisted that it be 15. But the person would have to argue that it doesn't apply the same.
Yeah, I mean, that's something became their consensual act when they were convicted has been made legal subsequently.
Yeah.
They got the benefit of it.
Senator White.
So when we're looking at this list of crimes that we are now in this bill considering exempting from, I hate to use the term good time, but that is what we're using, I guess. So can somebody give me, I'm still concerned that we're using categories instead of individuals here. And can somebody give me an example of, just in this one that you pointed out, Senator Sears, can somebody give me an example of what L&L with a child is other than this age thing? Can somebody just give me an example of somebody who might be convicted of that? Is it exposing yourself in the park at the playground? I mean, what is it?
That could be, touching of a person in their private areas that doesn't involve, could be over the clothes, could be, that kind of thing.
But it could be exposing yourself in the park.
Could be.
At the playground.
To a minor, yeah.
It seems to me that by including this whole category that, is mooning as you go from the high school football bus, is that lewd and lascivious? What is that?
That could be a lewd act, but not lewd and lascivious conduct with a child.
With a child, but it could be lewd.
Yeah, it's a different crime.
Okay, I'm just really concerned about exempting these from the good time.
Let's use maybe we should start using the term creating disqualifying crimes. So we're saying that certain crimes disqualify you from getting good time. And might be a better way to look at it than exempting. We're not exempting them. We're saying these are disqualifying crimes. And maybe we want to refer to this as earned time or earned credit or whatever we want to call it, if we don't want to use it for good time. The English professor in our midst might have a great word, a better phrase for this.
Earned time is good.
Anyway, so are we finished with the discussion about whether it's constitutional and whether we should not withstand whether we should not withstand Title 1, Section 214?
I and anybody, including Matt, should feel free to correct me if I'm wrong, but if we do notwithstand it, it makes the case, if it's adjudicated, stronger for what we would be trying to do, I believe. Matt might say ultimately it won't result in a successful verdict, but it would definitely strengthen the effort. I think so.
Eric, why don't you prepare an amendment that, I mean, pretty simple, I guess, to notwithstand something.
Yep, sure. You did it. You did it. You may recall having added the notwithstanding section 214 for the last session when you passed the statute that was permitting civil actions based on child sexual abuse. Remember where the statute of limitations had expired? So
Right.
we can do something similar here, certainly.
Senator White.
I have a hard time weighing in on whether we should do a withstanding or declare it unconstitutional or constitutional, since I'm not sure that I agree with creating disqualifying crimes in the first place. So just throw that in. So I can't weigh in on the withstanding.
Well, we can't notwithstand the Constitution, so there will be a battle over this. But
if we pass this.
If we pass the bill, we cannot say notwithstanding the constitutional right. But we can say notwithstanding what's the statute. We do that frequently, actually. We do it all the time in the darn budget, by the way. Somebody should pull up the notwithstandings in the budget every year, the big bill. I would, Eric prepared a list of the crimes that are disqualified, and I think we should kind of, excuse me, is Chris Fenno or Sarah Robinson want to chime in here on any of this first discussion about the constitutionality?
I'm not sure that I'm your gal for that, but Sarah Robinson, Deputy Director at the Vermont Network. I will just broadly say that, our primary concern throughout this conversation has been that, some of the most serious crimes that took the life of or had lifelong impacts on victims, that ought to be weighed in this process. And really what I think this committee has heard from victims, and certainly what we have heard from victims, is that it's extremely important to victims that the promise that they felt like they had from the state of Vermont is honored in terms of people that had been previously sentenced. And we do feel like the proposed language would ensure that that's the case. And in terms of people being sentenced moving forward, I know that sounds like you're about to have a conversation about which crimes may or may not be included. And I would just say that kind of parallel to that policy conversation, we still absolutely believe that there ought to be some language in the bill to ensure that victims are notified prior to sentencing moving forward, so that victims in the future aren't in a similar place as the victims that you have heard from over the past several weeks. So right now, there is no absolute right to notification. And in the conversations that victims may be having with prosecutors or victim advocates or others, they may be hearing about sentence lengths. And we do think it's important that prior to their opportunity to provide a victim impact statement, they can at least be aware of and just be noticed of the fact that whatever the statutory scheme ends up looking like, good time may or is not a possibility for the person that caused them harm, so that they are aware of that and clear about that moving forward from the time of sentencing.
I suppose that, but if we didn't change any of these crimes, well, I guess my example would be if we took manslaughter out, left murder in, and if somebody was trying to plea down to manslaughter, you're wanting the victim to be notified that if they get manslaughter, they would still look for a good time.
That's right. I think it's fair for all the parties to just be aware that the sentenced crime may look different, and victims ought to be aware of that in those considerations.
Aren't they notified of that now by the victims' advocates?
It's
Maybe
not
I need help from Chris here.
It's
I
not
think-
guaranteed that they are.
Chris Fenno from the Vermont Center for Crime Victim Services. Right now, the legislation that was passed, and I tested on it at the time, is that victims will be told at sentencing. So it would be explained to them what impact this might have on the sentence. And I personally think the prosecutor should do that. I think it probably will fall to the victim advocates. And I think that's a little problematic too, to make, they're not attorneys. So there might need to be some training and things that need to happen around that.
But if somebody commits a crime that's not disqualifying, they know they're going to get good time.
Yes.
So, I mean, there isn't an issue. I thought we have that under the Victims' Bill of Rights.
Yeah.
Right.
Senator Sears, I think that part of the issue is around plea bargaining, is that we heard last week from one victim's family that they pled out to a lesser charge. They could have been charged with homicide, but they didn't do that because they didn't want to have to sort of rehash everything that had happened to their daughter. So knowing that if he had been actually
You're muted for some reason, Chris.
they said they had evidence to charge him and have his sentence be life without parole, but that would have meant a trial. So they said, okay, we don't want to rehash everything that happened to her. But it's just that kind right now, what that means is that offender who got 34 years, I think, 43. But regardless of that, he now can, because he took that plea agreement, he can now earn time off of his sentence because of that. So what I think Sarah is alluding to is that those kinds of, if in fact S18 passes and becomes law, it's going to be really critical that the people who are explaining sentencing to victims understand what that means, and that prosecutors understand what that might mean to a victim to take a plea deal and move them into a category where they might be able to earn time off.
I think I understand what you're getting at. But, Eric,
I would just note that, it's not that victims are notified of the underlying sentence. That currently happens. But what would be helpful to have in the language is to ensure that victims have the right to understand, be notified of the potential impact of good time on the underlying sentence based on the offense.
Smashing my mailbox. I'm serious. If somebody smashes, what crimes are we talking? All crimes?
Just in the normal course of victim notification in the general court process right now, victims of all crimes have a right to be notified around sentencing of the person that caused them harm. And their primary place that they have a voice in the process is the victim impact statement. And so from our view, it's essential that they just understand, it's just clear to all parties when they are able to offer that statement about the potential impact for good time on the sentence, so that a victim can speak to that and the impact that it may have for them.
All right, I think I understand what you're asking for. Does it mean we have to rewrite the bill? We have to have an amendment?
I think if you want to guarantee that right for victims, there would need to be language, yes.
You have a suggestion?
I would be happy to send you some language, and I'd be happy to work with Chris on that and then send you something on behalf of both of us if that would be helpful.
That would be helpful.
Sure.
We don't have the state's attorneys represented here today, but we do have the Attorney General. Any thoughts, Mr. Attorney or Mr. Deputy Attorney General?
There's Joe.
Oh, Joe? Well, I
Yeah, I
asked
don't-
David a question, so maybe I should.
So I don't know when this started or why, but for the life of me, every felony that I'm doing a sentencing on, a judge will stop the proceeding if the victim hasn't been invited to the sentencing. And I don't know whether that was legislation that was passed or whether there was a rule that was imposed. It's just dawning on me that in virtually every case, sentencing can come to a complete standstill if there isn't an official waiver by the victim for appearing at the sentencing hearing. And I've seen it happen several times. I don't know where it began. I don't know if that's a statute or a rule.
I think it's part of the Victim's Bill of Rights.
It is. Yeah, I believe so.
So I don't
Well,
know if that needs to be amended here or what they're suggesting, but I don't have language right now.
Well, it would beg the question then, why would we want to add language to this particular bill?
Well, we asked them and they said they wanted it. I don't know. I mean, it's like it would be any amendment. Do we want to adopt it or not adopt it? They are witnesses suggesting that they want to make sure victims are fully aware of how a good time law that passed last October would impact that victim. That's what I understand what they're asking for. David?
Senator, just to answer your question and perhaps a couple others, we would support such an amendment if the committee were to consider it and adopt it. I think it goes to the core of what this bill does, which the policy this bill is trying to address, which is really a notice problem more than it is questioning the concept of earned good time. You know, under this bill, everybody moving forward retains the ability to get earned good time, and we support that and think that we believe in earned good time. We think that's a good thing. What this is trying to do is correct a very serious problem with respect to notice and fairness for people in the past who have already been sentenced and with victims who had a certain understanding of what that sentence meant. And we're trying to correct that unfairness. And I think in keeping with that, it makes sense to have a guarantee of notice with respect to earned good time moving forward. Again, that's very much in line with what we're trying to achieve in this bill, which is to make sure that victims have an adequate understanding of what's really happening, while at the same time allowing for what we believe is a good policy change, which is to allow earned good time. And again, we support keeping that possible for everybody in the future. I think it's a good balance, and that this addition would help achieve that balance.
I look forward to seeing something from both of you. And Eric, let me ask you a question. You and I discussed the other day the Texas model as an alternative here. And the Texas model is everybody still gets the good time no matter the sentence, but certain crimes, call them disqualifying crimes here, would not change the date of the parole. So in other words, while you could earn the time, you wouldn't change the parole date. So it wouldn't give somebody who had a 43-year minimum any earlier role.
Right. And we had looked at that a little bit. I thought you may recall, Senator Sears, you and I discussed that it seemed like that there was a more significant ex post facto problem with that approach because of the fact that it was clearly impacting someone's sentence by changing the date at which they could be eligible for parole. And that there seemed to be a number of cases, particularly on the parole point. Although, I see the based on what I've heard today, I think, the AG or defending whoever would be defending the statute might argue that there's a distinction based on the fact that what comes into play is the time that the defendant was sentenced, as opposed to what happened subsequently. But at least the cases I read seem to suggest that the parole, that the particular point of changing the date that someone retroactively changing the date that someone would be eligible for parole, seemed like the ex post facto issue was even more significant with that, if that were the approach. And as you point out, that's the approach that Texas takes. Not to say that it's going to get litigated anyway, so you could certainly try it.
That was another alternative.
Yeah.
James Peppers hopped on, and I wonder if you have a thought about the victims issue we were just talking about. I think you were watching us on YouTube. So, welcome.
Thank you. For the record, James Pepper, Department of State's Attorneys and Sheriffs. So this victim notification around good time was contemplated in the Justice Reinvestment Bill, Act 148. And there is a section there that maybe needs a little bit of modification, but I think it was at least in the contemplation of the committee that moving forward that the prosecutor would, at the time of sentencing, prosecutor's office, whether it's through the victim's advocate or from the state's attorney or prosecutor, him or herself, there's language that added that the prosecutor's office shall ensure that victims are made aware of their right to notification of an offender's scheduled release date pursuant to this section. So that was designed to begin the conversation with the victim at the time of sentencing about good time and the potential credit that could be earned against a min and a max. And perhaps it needs some clarification. And I also remember there's another section of the bill that said that DOC shall work on clarifying for prosecutors the potential for earning good time. So if a sentence is, 6 to 10 years, that the prosecutor at sentencing shall know precisely how much earned time could be earned, or how much good time could be earned at the time of sentencing. So if we want to clarify, exactly whose responsibility it is and at what point, that would be the section to do it in. But I think that this is, there's at least a requirement right now for state's attorneys to notify.
Thank you. So with that in mind, that's very helpful, Pepper. Thank you. Would it be okay to spend a few minutes? We've got about a half an hour left on what the crimes would be, whether we agree with all the disqualifying offenses that are listed here. And again, it's on our webpage, and it might be easier if Peggy could. It's up to all of you on the committee. We could have Peggy put the list of the crimes up. The first one listed on my page is 501 arson causing death. Would committee rather see it, or do you want to?
Sure, that's helpful.
Eric,
Well, you did send us the bill.
Yeah, but
Okay.
Is it different than what's in the bill? No, section C.
well,
right?
I mean, there's an explanation of the crime.
Oh, okay, great.
Okay, yes.
There's the actual statute.
Eric, do you want me to do it, or do you want to do it?
It has an explanation. Put it up, please. That would be helpful.
Let me see, hold on. I gotta-
Page, if you go to page 4 of the bill, C, and it says, as used in this section, disqualifying offense means, line 13, arson causing death, but then Eric has posted what exactly the statute is that you're considering disqualifying.
I would love to see that.
Okay, so why don't we post that?
It's posted, but I just pulled it up.
Okay, can you do a one pager or?
Yeah.
No, I meant the thing that's on our webpage that Eric provided.
Isn't this
Not-
it? That disqualifying? This is it?
No, that's
Yeah, there
for
it
the
is.
bill. Oh, yes,
501.
it is. Oh, I'm sorry. Yes, it is.
Yeah.
Okay.
It is.
Okay, can you just do one page at a time or?
And make it a little bigger.
Let's see. I don't know. That's how it came up when I posted it. Hold on. Let me see if I can figure this out. Sorry.
Look at, do the type size up,
How's that?
up above.
Hold on, guys. I think I might be able to do it. Hold on. Crap. How's that?
Eric,
That's
That's better.
Okay.
Good.
That's much better. Thank you.
You're welcome.
A person who willfully and maliciously burns the building of another or willfully and maliciously sets fire to a building owned in whole or in part by himself or herself by means of which the life of a person is lost shall be guilty of murder.
can I ask Eric a question about this?
Absolutely.
Eric, as I'm just reading this little synopsis, it seems as though the loss of life could be completely unintentional. Is that? Eric, can you hear me?
I have a feeling, Eric, because he never
Oh, no,
answered
Eric.
me either.
Okay.
So maybe he's had
Well,
to step away for a second.
I'll just put that out there.
Oh, wait, can you hear me? Can you hear me
Oh.
now?
Yeah,
Yes.
we can hear you now.
Sorry, sorry about that. But I understood the question, Senator Baruth, and you might not necessarily intend to kill the person by setting the fire. That's
Yep.
true. But the use of the terms, you'll see it's willfully and maliciously burns the building of another. So you have to intentionally set fire to the place, and maliciously means there is some bad intent. In other words, it's not just that you accidentally burned,
No,
left some matches.
I definitely see that, but it seems to me there's a distinction to be made between somebody who says, my neighbor that I've been having a property dispute with, I'm going to burn down his shed or a building he has, doesn't know that the person is in there.
Right.
So is it true that the law makes no distinction in that case?
I think in that case, right, you could, for example, the fact pattern you described, that could potentially be an arson causing death situation.
Because this goes back to Senator White's point about, disqualifying people and the purpose of prison as a reformatory system. If death resulted not through any intent of the person, then in my mind, what they intended to do was arson, which is, don't get me wrong, it's a horrible crime, but should that disqualify that person from ever receiving any benefit if they can demonstrate reformation? So that's one that's the only piece of that I stumble over. Whereas murder in the first degree, or premeditated murder, you've adjudicated it and proven that the person planned to do it and then did it. So I just throw that out there as a asterisk over arson causing death for me.
And I think
agree
just to follow up on that, Senator Baruth, if you were looking exactly at first degree murder, as you just were pointing out, the next paragraph down under 2301.
Yeah.
One of the ways in which first degree murder is possible is, in fact, if you've murdered someone while committing in perpetrating or attempting to perpetrate arson. See, that's that third
Okay.
line. So I think that covers the intentional situation, which yes, I'm intentionally taking the life of another person
Okay.
by fire. So
And the reasoning would be that if you intentionally do that crime or kidnapping, you're creating such a dangerous situation that you should know somebody could die in doing it.
I think that's, yep, you've described what's known in the law as felony murder, but that's exactly
Okay.
right. Yeah.
All right. Thank you.
Yep.
I agree with Philip on the arson one. I think that if somebody burns down the garden shed of their neighbor and they just happen to be asleep in the garden shed, that really isn't, in my mind, premeditated murder. It's arson.
That's what
Could
the
be
law
a lot
says.
clearer. It could be a lot easier to see if you recognize the language could result in somebody running out to hose down the garden shed while it's burning, and then the garden shed collapses on them. The same could apply in this particular situation. I agree. I don't think this should be in this exclusion category.
Okay, is that a majority opinion?
An apparent majority.
I don't
Apparent
mind
majority.
it being in there, but to go along, okay.
Murder, first and second degree penalties. Well, actually, murder defined. Section 2301.
Yeah.
What does, may I ask a question?
No.
What does, or a wanton under second degree, or a wanton disregard of the likelihood that death or great bodily harm would result? So we're lumping in great bodily harm with death here in
No,
murder. It says, or great bodily harm is second
intent to do
degree,
great
or,
bodily harm.
huh?
The person didn't die, but there was an intent to kill the person. That's how I read it.
Or it says,
Eric, can you answer the question?
I think it means that the possibilities for the second degree murder charge, that you intend to kill the person, that's the first clause, or you intend to do great bodily harm, but the person dies anyway. You still have to have the death, but your intent was to do great bodily harm. Or by wanton disregard, that's generally another way to phrase recklessness. So that's it's more than negligence, because you'll see negligently causing the death of another person can be a manslaughter charge, but wanton disregard is generally reckless. You conscious disregard of a known risk. You know that something is risky, you do it anyway. You know that death or serious bodily harm could result from what you do, but you do it anyway.
Push them off a cliff.
Right, that's a good example.
So my
I'm sorry, I
question
didn't
is,
catch that, Alice.
Then you push them off a cliff.
Yeah,
By some miracle they live, but you intend.
so my question is it considered second degree murder if the person doesn't die, but they have suffered great bodily harm?
No, but it could be attempted second degree murder. If the person doesn't die, you can't have a murder if the person didn't die, but it could be attempted.
So where is attempted second?
Attempts
The
are in
same
a
punishment.
separate statute, but it
Okay,
generally
all right,
speaking,
thank you.
attempts are, yep,
Thank you.
sure.
I think it should, if anything should be in there, this should,
That should be in there.
my opinion.
I agree.
Okay. Explain the difference between voluntary and involuntary manslaughter.
Yes, Peggy, can you hear me? Would you be able to move the page down, please? so that you want to have voluntary, yep, okay, a little bit more. Actually, that's fine, that's perfect. Because now you can see in front of you, I think, does everybody see that you have bolded both voluntary and involuntary manslaughter?
Yes.
Right, so the difference is whether or not there's been an intent to take human life, essentially, the difference between voluntary manslaughter and involuntary. You see, the voluntary manslaughter is an intentional, unlawful killing of another human being, but it's committed under sudden passion or great provocation that mitigates the killing. So that's, a situation where, someone's emotions have risen to the level of sudden passion or provocation. In that case, it's very common and long been held in the law that those are mitigating factors to the taking of another life. So perhaps makes it ameliorates the culpability, essentially, not as culpable because of the existence of this provocation. The person's been provoked or some rise in the passion. And that can reduce a charge of murder to voluntary manslaughter. And you see this language here is from the model jury instructions, which I took from the Vermont Bar Association's webpage. Now, involuntary manslaughter, on the other hand, you see, look down to the next paragraph, is an unlawful killing. So in other words, it's not justified, it's not self-defense or something like that, but it's not done with the intent to take human life. So you cause the death of another person, but you didn't intend to do so. You see the second sentence, it's an unintentional killing, where the person acts either recklessly by disregarding, and again, I said earlier, recklessness is conscious disregard of a known risk. You know something is risky and you engage in the conduct anyway. Or it could be criminal negligence. You see, that's the second bracketed phrase. Could be you unintentionally killed somebody, but you acted negligently. You acted unreasonably under the circumstances. You had a duty of care, and your reasonableness under the circumstances to take care, you failed to do so. And if you do that and accidentally cause the death of another person, then it can be involuntary manslaughter. You see the penalties as well, I included there just so you could see that the penalties for manslaughter are much, much lower than the penalties for murder. It's only a 1 year minimum, 15-year maximum, whereas the murder penalties are 35 years to life. So significantly different, because obviously the culpability in the two situations is very different. That sort of help understand the concept?
Yeah.
Can I just ask a question?
Yeah.
But they're both included under number 3. It doesn't give you any option with regard to voluntary or involuntary. Is that correct?
Yes, that's correct, Senator Nick.
Thanks.
It seems, well, that's a good explanation of it. I'm not sure it belongs or doesn't belong. I'm happy to hear arguments from those that are in the room right now, which includes committee members as well as the judge, state attorney, victims group, Matt Valerio.
I would say it doesn't belong.
I certainly think voluntary does belong, but it's not separating out the two.
Well, can I just ask a question about what would be the result of this issue? Somebody goes to confront somebody that they have been that has been bullying them, consistently bullying them. And they go with a gun with the intention of confronting the person and then shooting themselves because they're so depressed. In the process, the person begins his bullying again and continues to bull. And the person loses it and shoots him. Now, it seems to me that that's voluntary manslaughter because it's in the height of a passion, and he never had an intent to shoot that other person, but it's included under here as as something that can't be qualified for. Is that my understanding, Eric, is that that's the way that would work. That would be voluntary manslaughter.
I think my reading of it is that what you described, that could be provocation, and that's the word. So that conceivably could be a voluntary manslaughter situation. I think I'd also defer to Matt and David with more experience in practice with this than I, but
I wonder
certainly
if anybody, David, Matt, or Pepper, or folks from the victim. I can't see everybody right now, so.
The cases that I've handled like this that have the voluntary manslaughter, you're really looking at the difference between voluntary manslaughter and second degree as more than voluntary manslaughter and involuntary manslaughter. What tends to happen is if you have what would otherwise be a second degree murder, where you have great provocation or sudden passion, it reduces the second degree murder to a voluntary manslaughter. And these arise oftentimes, there are a bunch of different ways it arises. One of the ways it arises is somebody gets involved in a mutual fight and then uses excessive force to try to extricate themselves from the fight or the like, and somebody dies as a result. So, it's kind of the somebody pulls a knife during a fist fight. Somebody, there's a big brawl going on, and somebody picks up a baseball bat and hits somebody in the head or something, and they end up dying as a result. Now, they didn't intend to kill them, but the provocation was there as a result of the fight. The other thing that's kind of the typical one that you hear about is somebody comes home and finds somebody in bed with their wife. And so they, go start beating on the guy or whatever it is. And that's the sudden passion, where you don't have an intent necessarily to kill, but the person ends up dying as a result of that. There's cases down in the Windham County area. I recall one that one of our guys did, where there was a fight outside a bar. The guy got punched in the head and fell on the side of the curb, hit his head, and he ended up the guy who fell ended up dying. That is another example of maybe the distinction between voluntary manslaughter and involuntary manslaughter. Involuntary manslaughter is, of course, is pure, really almost pure negligence situation, where there was no intent to kill, or even to understand that what you were doing might have resulted in the death. It's a mistake that results in the death of somebody else. And that's, to me, that I would definitely push that out of there. And I feel the same way about voluntary manslaughter, only because the issue really is what are you trying to deter in the conduct? You can't deter an unintentional act. You can't, if the intent wasn't to cause the death, or if placed in the same or similar situation, the death was the accident, even if the act was intentional. It implicates what we call imperfect self-defense type arguments, where somebody maybe reasonably believes, or they believe, that they have to use a certain level of force, but they overreacted. You can end up in a question, the on the edge of voluntary manslaughter versus second degree murder. If a jury finds voluntary manslaughter, if the pleas to voluntary manslaughter, what you're saying is that it's something less than a unmitigated attempt to kill, or intention to kill. So, I gave you some examples. I have said before that I think the manslaughter should be out, and I understand second degree, first degree murder if it goes this route. And remember, what you're doing here is excluding somebody from the opportunity to have, it allows them to get good time. You're not changing their It's not the sentence that's being impacted. It's their eligibility for release at the time of, with good time off the minimum. So,
Thanks, Matt.
That's the key. So,
David Sure, is there a reason manslaughter was in here? And if so, why should we keep it?
Thanks, Senator. The list was originally generated as one that was an attempt to focus on the most serious crimes in Vermont. The catalog of Vermont crimes. And in developing that list, we looked to the Big 12, but we felt that the Big 12 was actually too many, and we wanted to reduce our reliance on those pre-existing lists. So we took a subsection of the Big 12. There's 8 here. A couple of them actually are not from the Big 12, but fall within the sort of category of the very serious crimes, including aggravated sexual assault on a child. I think it's important to remember for something like this, these are still crimes where somebody has lost their life and somebody's lost a family member. And I also want to emphasize, and that's a very serious loss. We're not talking about purely accidental behavior where there would not be any crime involved. And the other thing I want to emphasize here is what the committee is doing is a relatively narrow thing, in that all you're guaranteeing that you'll do by passing this bill is that people who have already been sentenced and with a particular understanding of what and the victims had a particular understanding of what that sentence was, the family members of the people who died in this case had a particular understanding of what that sentence was, those people are going to retain the same sentence they had before. Again, in the future, the bill does allow for anybody to get earned good time. So I just want to reemphasize that we are talking about past sentences here, not that this committee is going to drastically reform how sentences will be granted in the future.
Yeah. Okay. Anybody else who wants to speak on this?
So Senator Sears, can I just say,
Yep.
so if I understood Matt right from before, the manslaughter sentence, is it true, Matt? It's a 50 only, but it's a 15-year maximum.
Yes.
So
$3,000 fine or in prison for not less than 1 year, not more than 15. So somebody could actually get a 1 year sentence.
jeez.
it's not unusual in close cases like this to even see just suspended sentences.
Even on the voluntary?
Not so much on the voluntary. I mean, those are typically, you see 5 to 15s. The real serious, if it looked like, there's some that look more like involuntary manslaughters than voluntary manslaughters, and those are the ones that are going to get the 5 to 15 if they're voluntary. There are others that look more like second degree murder but end up as voluntary manslaughters, and those are going to get the ones that are like 10 to 15 or like the higher minimums.
Either of the victims community members here want to speak, or James Pepper?
Are they all still on?
I don't know.
Sarah-
I can't.
Sarah
I'm having
Robinson here.
Sarah,
Oh.
Yes, I'll just say on what you have covered so far that, we supported the bills that were identified by the Attorney General exactly for the reasons that the Assistant Attorney General outlined. That it was a narrower subset of bills, not the Big 12, that these were bills that had really lifetime impacts on the victims.
Sorry.
thank you.
And I would concur with that. This is Chris Fenno. The list came out of the Attorney General's office. It seemed reasonable. I am a little concerned because I thought this wasn't going to just be applying to past, but also to forward.
Yes.
So it has no effect on somebody who commits first degree murder now.
If I could just clarify.
No, it will. No. Yeah. No, it will affect anybody who does it now. We focused, in terms of the ex post facto and those other things, we focused on those who are currently sentenced.
Right.
But if the bill passes, it would affect everybody who's sentenced after the date of, or actually, I don't know if the date of the crime or the date of the sentence. David?
I just wanted to clarify, the bill does contemplate a petition process for
Right.
these crimes going forward. So everybody retains the ability to get it. They don't have a guarantee of getting it as the bill is currently drafted.
But
Right.
may I ask David a question about that? This is
Mm.
Jeanette. So, you just said that this would allow them to, going forward, to petition, but isn't that the same for the past? It allows them, nothing in this, in what we passed before says that anybody's sentence will be reduced. It says that the date by which they can petition for or have a hearing might be moved forward or backward, whichever you want to call it. But it doesn't guarantee that they're going to be released. It just guarantees that they will have a hearing at which anybody can come and testify about
No,
why they should or should not. And
You're talking about two separate processes. You're talking about the parole process. You're
Yeah,
correct. Somebody who's currently sentenced, when they come up for parole, they don't automatically get parole.
right.
But he's talking about a petition process that would take place before the court if you were sentenced after the effective date of this and you committed one of these crimes or convicted of one of these crimes, you could petition to earn good time. And that's how the bill reads.
But wouldn't you still have to then go before somebody to, so you can petition to get the good time, but just because you get it doesn't mean that you're going to be released. Wouldn't you still have to go before somebody and have a
Yes.
hearing?
Yeah.
Okay, that's my question.
This would be an earlier date that you'd be able to
Right.
get the hearing than you would
Right.
otherwise.
But it doesn't guarantee anything except
No.
an earlier hearing.
Right.
Yeah.
So the question was, should we keep manslaughter in?
No.
One no,
2 no's.
two no,
3 no's.
3 no's.
I'd say
Okay.
yes. I'd say yes with the fact that I'd rather it was just voluntary kept in. But
Okay, well, it's 3 to 1 to 1.
what's the,
What's the one? I haven't voted yet.
Oh.
I agree with you. It'd be better if voluntary were.
can't we just write it that way?
Well, we could.
Put involuntary manslaughter.
I don't know. There's with 3 votes to take all manslaughter out.
Oh, okay.
No. Kidnapping.
Peggy, can we move down a little bit? Thank you very much. Appreciate it.
Is there anybody currently incarcerated for kidnapping?
We do get those cases. I know I'm assigning them on occasion to the prisoners, or I mean, to the serious felony units when they come up because of the potential for life in prison in them. A lot of times they're charged as kidnappings and pled to something else. You see them arise a lot of times in domestic cases and sexual assault cases where somebody is held for even a small amount of time during the assault, and then it's charged to try to enhance or the state's bargaining power, basically.
My question though was, is there anybody currently sentenced who would be impacted by this?
I'm sure there is, actually. There's not many of all of these. I mean, you're talking about a couple handfuls, maybe, if you added them all together.
Can I ask Matt a question?
Sure.
Did you say that there are cases where, and I see here that B, that where somebody temporarily holds someone in some kind of a standoff or whatever it is and holds them temporarily as a hostage and then releases them, that they can be charged with kidnapping? Is that what you said?
Yes, because there's kidnapping and there's unlawful restraint, and they're different charges. But oftentimes what you'll find, you can do that, but people think of kidnapping, they think of, the Lindbergh baby or something. That is, clearly kidnapping. But kidnapping also can be holding somebody for a small amount of time, literally some number of minutes can result in a kidnapping charge. It's obviously serious, but they arise a lot in domestic cases and sexual assaults where the perpetrator is not letting the person go during the course of the assault, and then you get a charge on top of your domestic or sex case of kidnapping to up the ante.
I would support keeping kidnapping in.
I would too. It's such a wide range, but it's horrible.
It's a wide range. I just would, well, if somebody is holed up in an apartment and they have somebody there and they're not hurting them, but they're not letting them go, it seems to me they shouldn't be being charged with kidnap, but if they eventually let them go. But that's, I don't understand our criminal justice system at all. It makes no sense to me. It just
Actually,
makes,
you do.
it makes no sense to me the way we charge and treat and define things and anyway.
But this is what they're sentenced to for.
Yeah.
Well,
So if they hold them for 15 minutes, then they're going to be charged with kidnapping. That
they
doesn't
may
make
be
any
charged
sense.
with it. They may be charged with it, but what will they be sentenced to?
Well,
We're going to pick up here next Tuesday. And I'm going to suggest that we pick up with lewd and lascivious conduct with a child. And Eric, if you could just find out for us, I really need, it's been a while since I've gone over L&L with a child, and we've got jury instructions and all of that, reporter's notes. So it might be helpful for us to have a thorough foundation of L&L with a child, because it can involve lots of different scenarios, right?
could Eric send that maybe to whatever he comes up with to us in an email, and then I can print it off, so because it's so hard for me to read it on the screen.
Well, yeah, I mean,
Okay.
I think that's going to be one of the tougher ones. I already identified A2, the section shall not apply if the person's less than 19 and the child is 15. But if the person's 19 years old in one day and the child's 15, they could be charged with L&L conduct with a child. Or if the child is 14 in 364 days.
Yeah, that sounds good. And also just on that point, Senator Sears, you may recall that you used a different age gap in the sex offender registry statute. I only point that out to say that you can certainly adjust that for purposes of the good time law if you wanted to.
Okay.
Without adjusting the underlying offense, I mean.
Right. I know I get position in the body.
right?
If you could remind us of what we did in the sex offender registry.
Yeah, sure. I'll put that in the summary.
Does
Thank you.
everybody, and are there any of the sexual assault versus aggravated sexual assault?
I have to look at I'd like to look at the definitions of each.
Yeah,
Well, that's what I'm asking Eric to do, is a little summary for us.
yeah.
Those ones in the document you have are pretty straightforward.
Okay,
Much clearer than the L&L with the child.
all right.
So you can see the sexual assault. It's limited to only two types of the sexual assault violation, either without consent or three, threat or coercion, or placing the other person in fear that they're going to suffer imminent bodily injury. So you don't have the same sort of lascivious sort of terms that are open to interpretation that you have in the L&L statute.
Okay. So my plan,
And Senator Sears, by then you should have your Title 13 because Tony mailed it yesterday.
great, thank you. So my plan is to take this up again next Tuesday, same format. And hopefully, oh, my printer's out of paper. And hopefully we'll be able to move this bill forward on Tuesday. Or not. So,
Mr.
do
Chair,
you
I
have
just
any-
wanted, oh,
yeah, go ahead.
I just wanted to say, to reiterate my feeling, I got a little confused about what David Scher was saying. He was referring to it as though the bill going forward included everybody. I understood the bill is introduced to continue the exclusions going forward.
Yes.
And I had said that I could vote for something that was excluding retroactively, but not prospectively. So I just wanted to clarify that.
Right. Yeah, you would support dealing with those that have already been sentenced, but not those that
Have yet to be sentenced.
yet to be sentenced.
Yeah.
I remember that.
Okay.
All
And I
right,
would
so
Sorry.
we've got some difficult decisions to make. First of all, what does the final draft look like? And then if we want to amend it further to Senator Bruce's position, or do we want to go forward with the Attorney General's position?
I didn't quite hear Phil, what Phil wanted. You wanted to apply to before and after.
No,
So I had asked the Attorney General when he testified why it wasn't just excluding those offenses where there had been an agreement prior to passage of the bill on the length of the sentence, if the purpose of the bill was to keep good faith with victims. Because going forward, everybody would be informed that all categories would be eligible for good time. Does that make sense, Alice?
So you're comfortable with just going forward, trying to
No.
ascertain that?
doing the past.
You want to do the past and the present and the future. I mean, the past and.
No,
Just
Oh,
the
Not
bill
the
does,
future.
the bill does everybody who's sentenced in the future, as well as those currently sentenced
Right,
on the effective date of the bill.
okay.
What I think Senator Baruth's talking about is only making it effective for those where a deal was made, the victims were involved.
Yeah,
And in the future, the victim would
Would
know
be
that
informed. Yeah.
be informed of the good time that the person might receive, and it would be a different, there hadn't been an agreement. that
Yep, I
included-
understand.
So
Yep.
Okay,
that's what. Okay,
very good.
good. We'll see.